Imagine your loved one passes away, leaving you a significant inheritance. You trust the person in charge of the estate. It's either a close family member or a friend, and you think they'll do the right thing. But weeks turn into months, and excuses start piling up. Communication gets spotty, money seems to be vanishing, and by the time you realize what's happening, a huge chunk of your inheritance is gone, like the wind. Spent on personal luxuries, just lost to bad decisions. This isn't just a nightmare, it's a scenario. It's a devastating reality that too many families often deal with. And the one thing that could have stopped it is a little known court document. It's called a probate bond. But that little piece of paper is so powerful. And today I'm going to show you how it can be the single most important defense of your family's assets. Let's talk. Thank you guys for joining me today. I am Rob Moore, aka Real Estate Rob. So when someone dies, their estate, everything from their house and their car and their bank accounts and investments, enters a legal process called probate. If you've been following my series, you know a little bit about it, but this is a court-supervised procedure, and it's designed for a few things. Number one, to make sure the deceased will is valid, pay off any debts and taxes, and legally transfer what's left to the heirs.
Who's supposed to manage this?
To manage all this, the court appoints someone to act as a fiduciary. If there's a will, this person is usually the executor, which is named in it. If there's no will, the court appoints an administrator. We'll mostly use the term executor here, but their duties are pretty much the same. This person holds an immense amount of power. They're responsible for things like gathering all the assets, notifying everyone who needs to know, paying bills, filing final taxes, and finally distributing the inheritance after all of that is complete. You see, they have a fiduciary duty, which is a legal fancy term for obligation. And they have an obligation to act in the best interest of the estate and its beneficiaries. But here's the scary part. What happens when that trust is broken? What if the executor starts using the estate's bank account as their personal piggy bank? Or what if they're just plain incompetent and make costly mistakes, like forgetting to pay taxes, which leads to massive penalties that drains the estate's value? This is where things can go horribly, horribly wrong. Executor misconduct can range from blatant theft to quiet mismanagement. Some executors might sell an estate property to themselves for a fraction of its real value. Others might play favorites, giving assets to one beneficiary over another, completely ignoring the will. Even just dragging their feet can be a problem. If an executor takes way too long to settle the estate, asset values can drop, and everyone is left in a painful limbo. In most cases, the warning signs are often there, though. You got to pay attention. There's poor communication, unexplained delays, and vague answers to financial questions. When this happens, beneficiaries can feel powerless, and trying to remove a dishonest executor in court can be long and expensive. Even if you win, getting the stolen money back can be nearly impossible, especially if the executor has already spent it. And that's exactly the problem a probate bond is designed to solve. So what exactly is a probate bond? A probate bond, sometimes called a fiduciary bond, is basically an insurance policy that guarantees the executor will do their job honestly and legally. It's a financial safety net required by the court to protect the beneficiaries and creditors from fraud or screw-ups. Think of it as a three-way agreement between the executor, the court, and an insurance company called a surety company. Here's how it works. The court orders the executor to get a bond. The executor applies to a surety company, which checks out their financial background and the estate's value. If they're approved, the executor pays a premium and the surety company issues the bond. This premium is usually a small percentage of the bond's total value, often around 0.5% to 1%, and it's paid for out of the state's funds. So it doesn't come from the executor's own pocket, just so you know. The bond amount is typically set by the court, and it's to cover the total value of the state's property and any income it generates. For an estate worth, say, $500,000, the bond might be for that full amount, while the yearly premium could be just a few $1,000s. Now here's the most important part. If the executor messes up, let's say they steal $50,000, the beneficiaries can file a claim against the bond. The surety company investigates. If the claim is valid, the surety company pays the beneficiaries for the loss up to the full value of the bond. Then the surety company has the right to go after the executor to get that money back. And we know insurance companies, they like getting their money. So this gives the heirs a direct path to getting their money back instead of having to sue a crooked executor who might not have any money left. They have a claim with a stable insurance company. The bond ensures that even if the executor is broke, inheritance is protected. It turns a potential disaster into a recoverable loss, which is the primary role for an insurance bond. Here's a few cases in which a court almost always requires a bond. When someone dies without a will, when the will doesn't specifically say a bond isn't needed, and also when minors are involved, or when the executor lives out of state. However, some jurisdictions might waive the requirement altogether if the will says to, and all the heirs agree. The bond forces the executor to be accountable, knowing a major insurance company is vouching for their integrity. Not all probate bonds are one size fits all. Their names often change depending on who's managing the assets. They all do the same basic job of protecting the estate, but knowing the different types helps clarify who actually needs one. The most common are what is called executor bonds and administrator bonds. An executor bond is for the person named in a will. An administrator bond is for when there's no will and the court appoints someone. In both scenarios, the bond guarantees they'll do their job, they'll do their duty. And beyond those, there are other important variations. You have a personal representative bond. It's more of a general term that can cover either an executor or an administrator. Then there are bonds designed to protect the vulnerable. A guardianship bond is for a guardian appointed to manage the finances of a minor or an incapacitated adult, making sure they don't misuse the person's assets. Similarly, a conservatorship bond protects an adult who can't manage their own finances from being exploited by the court-appointed conservator. A trustee bond might be required for a trustee who manages assets in a trust. Even though trusts usually skip probate, a court still can demand a bond to make sure the trustee follows the rules of the trust. Each of these bonds, whether it's for an executor, a guardian, or a trustee, acts as a critical check on their power, like checks and balances. They all work on the same principle, providing a financial guarantee that the person in charge of someone else's money will act responsibly. Without that guarantee, you're left relying on pure trust. And as we all know, sometimes trust isn't enough, especially when a family member passes, there's an inheritance and money is involved. It's not like there won't be a big fight. Look, the probate process is complex and the stakes are incredibly high. The best way to protect your family is with proactive estate planning. But if you find yourself involved in a probate case, either as an heir or the executor, understanding your rights is the first step. If you suspect any kind of mismanagement, from radio silence to straight up theft, don't wait. Talking with a qualified probate attorney can give you the clarity you need to handle the situation, and if necessary, take action to protect your inheritance. Don't let a loved one's final wishes be destroyed by dishonesty or incompetence. Losing a loved one is a time of grief and emotional chaos. I know this firsthand. The last thing any family needs is the extra pain of financial betrayal. A probate bond is like a silent guardian, a financial backstop that ensures there's accountability when it matters most. It gives executors a powerful reason to act with integrity and gives heirs a clear path to recovery if they don't. While it might seem like just another boring piece of legal paperwork, a probate bond can be the difference between a secure future and a devastating financial loss. It protects beneficiaries, makes sure debts are paid, and honors the final wishes of the person who passed away. We may place our trust in people, but the law provides a way to verify that trust. And in the world of estates, that protection is priceless. All right, guys, thank you for joining me today. You could have been anywhere in the world, but you chose to be here with me. I am greatly appreciative. Now, maybe you're not going through probate and you just happen to come across this video and you think, it's no good for me. But I do happen to know someone who's going through probate. Feel free to go ahead and like and share this video so the algorithm will know it's at least doing something and serving its purpose. Now, if you've been keeping up on this probate series, you're pretty familiar with the probate and how things work. And in my last video, it was titled, Can You Sell a Probate Home in North Carolina Before the Process is Complete? You can find out the answer to that question because that video is coming up next.